Question. Madam, Port Officer.
ಸರ್ ಹೇಳಿ. ಸರ್ ಹೇಳಿ.
ಧಾರವಾಡ ಬೆಂಚ್ ಮೇಡಮ್, ಇದು ಧಾರವಾಡ ಬೆಂಚ್ ಕನೆಕ್ಟ್ ಆಗಿರೋದಾ?
ಇಲ್ಲ ಸರ್, ಇಲ್ಲ ಇಲ್ಲ.
ನಿಮ್ದೆ
ನೀವೇನಾ?
ಮಾಡೋ
ಎಲ್ಲ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರು. ಸರ್ಕಾರದಲ್ಲಿ ಕೆಲಸ ಮಾಡಬೇಕು ಅಂದ್ರೆ you should have that service mindset.
Correct.
Otherwise, now there was some discussion
Last week,
ಅದರಲ್ಲಿ ಏನಂದ್ರೆ why is it that most of the judges, it is not only in Karnataka but elsewhere in the country, we find that most of the judges who are getting elevated for either in the government panels or unsworn school. Then the reason why this is taken is because by working so hard for an entity or like a government agency or government, receiving such peanuts.
Enough.
Okay, they have already entered into the mindset of rendering service. So that is what is actually required of the judge. Judge service certified. ಅದಕ್ಕೆ ಗರಡಿ ಬಸ್ಕಿ ಗಿಸ್ಕಿ ಓಡಿಸಿ ಇಲ್ಲಿ ಚೆನ್ನಾಗಿ
I have not seen your practice. You retired as a Supreme Court judge. Convincing just.
they turned out to be good judges also. But what we have is that most of them turned out to be very good.
Forest Department of Vide mentioned regularization,
service to Vikas of Vikas project.
Court of Sir procedure.
How good it is?
Reasonable.
ಇಲ್ಲ ರಾಘವೇಂದ್ರ
ಏನಿಲ್ಲ ಒಳ್ಳೇದಿಲ್ಲ ಮೇಡಮ್ ಸಿಟ್ಟಿಂಗ್ ಲೇಟ್ ಆಗುತ್ತಾ
Ask AC to be present before. Because in the person, which one is yours? Which of yours is faster?
He doesn't know the serial number.
18. Was this TV always here or did it come recently? No. Somehow don't remember. Adjournment.
Yes, kind. Ashwatthappa ಏನು?
Yesterday, your lordship, one interim order came to be passed by your lordship, wherein as transfer order has been stayed, that petitioner was also reported the duty at Madikeri on 17/4/2025. After that, this order came to be passed. Lord, both of them reported on their respective transfer places. And
ಈಗ ಏನಾಗಬೇಕು?
now kindly have it tomorrow or week end of the list today itself.
Not possible.
Tomorrow, my lord, at least, because they are already working over there in the respective transferring places. And the petitioner was there in Bangalore from 2004, more than 20 years. Those are the, she came before this court several times, got an order and continued in Bangalore.
No, day after tomorrow.
My lord, kindly tomorrow, because my lord, your lordship said in that,
Nothing illa.
forthwith the order should
Next,
be implemented.
One
That is why.
unusual mentioning, my lords. I'm sorry, my lord.
Day after tomorrow, my lord.
If my lords could recollect, my lord, matter pertains to 371J, Article 371J.
How we can
Lord,
take
I am
now?
completely, Boda, I completely understand, Lord. I'm only requesting your lordship, for this reason, Lord, it was heard extensively, my lord.
That's true. But what can we be? You have seen the development now.
Completely, it's so unfortunate. We'll certainly take a chance, if my lords permit. My lords permit.
Allah, the other judges to come from that place.
I know the difficulty, my lord, I am completely aware of that.
ಹಂಗಾಗಿ
In the interest of the many students, my lord, the candidates,
ಇಸ್ಕೊಳ್ಳಿ ನೋಡೋಣ, we'll speak to
so grateful, my lord. So,
concerned.
any date, my lords, any date.
ನೋಡೋಣ that.
Grateful, we'll see.
As do matter, serial number 16, Siri Rajshekar.
Lords appearing for the,
Petitioner.
Lords the Panchayat Development Officer was rather a district cadre. All the appointments of about 6,200 Panchayat Development Officers were made by treating it as a district cadre, and transfers were permitted within the district. Now, by virtue of the impugned notification, it is sought to be converted into a state cadre. Not
The
the
district order, another.
district cadre, not the terms of appointment and the, of course, it is, I don't say that it is not permissible wholesale. But whenever they convert a local cadre into a statewide cadre or a larger cadre, the first and foremost thing is they will have to come out with a formula for the purposes of ensuring that the service conditions, the avenues for promotion and seniority is not affected in any manner. This is what is absolutely
Committee
required.
ಮಾಡಿ ಇದನ್ನೆಲ್ಲ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ. ಎರಡನೇದು ಪ್ರಾಬ್ಲಮ್ ಏನು ಅಂತಂದ್ರೆ, this is a group C post. ಈ group C post employees ಗೆಲ್ಲ PDO ಎಲ್ಲ, PDOs will be posted to the democratically elected bodies. To regulate a transfer statewide for a PDO officer would be very, very disastrous. Because even for the group C cadres, they have region-wise bifurcations. Usually, what they do is that inter-region transfers in respect of certain cadres of officers is not permitted beyond the region unless it comes within the exceptional categories. Here, they will have to serve in the bodies which is headed by the elected representatives. And it will not be in the interest of.
Sure, that they were a part of the district cadre.
So that's an admitted fact.
They admitted.
Yes, that's an.
You admit that it's a district cadre. Then all of a sudden, how you converted it into state cadre? You have power to do it, one thing. What is the process by which you have existence of power is one thing, exercise of power is another. You may have power to hang somebody to the nearest tree, but you have power, therefore I will hang them is no rule of law. So what is the process under which the district cadre metamorphosed into state cadre? How that is done?
Page 213 minutes.
213.
Schedule 2 at page 215.
State cadre was under challenge on several grounds, and it was quashed, and thereafter the error in converting was rectified because it was not done under the KCS Act, Karnataka Civil Services Act. Thereafter, it was rectified. It was subject matter of challenge before the honorable tribunal.
Read which provision?
Page 215 minutes. Schedule
15.
Yes.
This ninth schedule, serial number 9.
Yes, at page 215, clause 4 minutes of the rules.
Insertion of new schedule.
Yes, insertion of new schedule. Category of post senior Panchayat development officer, cadre is state cadre. And the next serial number 2, Panchayat development officer, it is state cadre. So they convert this into a state cadre from a district cadre.
No, how this was done? How this has been done? This is not a statute. This is a rule. How the rule? Give us the power to make rules. What is that? How it runs? 1970 Act Code. How this is done? What is the
notification, the preamble of the notification?
That's all. What is the process? How that is done?
Under the KCS Act.
But,
page 213, the preamble of the notification refers to the Act.
It's a copy.
Karnataka State Civil Service Act 1978.
did you object to this one?
Lords, we objected.
Where is that copy?
Lords, we have produced that copy of the objections at Annexure A7. Lord, this is the ground which we raised before the tribunal, saying that.
Where is your objection?
Lords, objection is at A7.
A7.
Yes.
Page number?
Lords, that is.
208.
Please, Lords. Individual representations are also given. Representations are also given through the association. Lords, there is a requirement of consideration. Lords, it is not because if you are, there is a possibility of altering the service conditions which was originally there when we got appointed, then it is not merely an objective satisfaction. It is not merely a subjective satisfaction. There should be an objective satisfaction to consider the objections within 1 day. No reasons are assigned.
You give representation on which date?
Lord, 7/3/2024.
But that, this is 8/2/2024.
Please,
Give
7/3/24, 13/3/24, the notification is made, my lords.
7/3, 13/3 is given there.
Yes, 13/3.
Where is consideration, brother? Where is consideration of the representation?
My lord, fresh matter, my lord, if notice is issued, we'll get instructions. Very first time it is.
Which we
received.
should have said, saying that.
My lord,
You
earlier-
have said objections are considered. Means what? Objection should be objectively considered. Consideration should be reflected from a small read of the provision. Saying that a justice is done. Yes, justice is done anta nange agtade.
My lord, as long ago as 2010, the exercise commenced, my lord, in fact.
That's all right.
But
We want to know.
Initially, by an executive order, it was done.
First lacuna in administrative law, which our professor Vishweshwaraya used to say, where you are making a subordinate legislation. Kindly go to section. Which section it is, which gives power to make rules?
Section 3.
Section 3. Face that section.
Please, my lords.
Sorry. Power to make rules. Okay. Section 8.
Mantra. Okay, kodi.
When did you lay these rules in the house for affirmation?
It's not done. Even now, it's not done.
But that ground you have not taken.
Lords, that ground is raised before the tribunal.
That was raised.
That was raised. Lords, a tribunal passes a very cryptic order.
Where have you laying procedure? Where have you, when it was laid, when the legislature saw these rules, because these rules become as if enacted in the act.
We'll get instructions, my lord.
What was the stand before the tribunal? Where did you take up that contention before the tribunal?
Lords, we have taken up that contention, Lords. I just point out to that.
How that is treated by the tribunal?
Lords, tribunal's order is very, very, Lords,
All
cryptic.
right, where have you taken up?
Lords,
that
I just
contention?
point out, Lords, I made a mark of this.
Rules themselves should say that they were laid before the house. This is what C.K. Allen in the famous book Law in the Making writes. The famous judge, which is that? Atlas cycle sources so and so, which is that famous judgment. When it was laid, for how long they were laid, and what the legislature said, because these rules become as if enacted in the act. Contention
I'll just point out, Lords, because when I was preparing this, I had read it, Lords.
Which is that judgment, laying procedure. Atlas cycle alla no?
Please, Lords.
Huh?
Atlas Cycle Industries.
ಯಾವ್ದದು ಜಡ್ಜ್ಮೆಂಟ್ SEC AR Jain in administrative law, 6th edition by Justice Aradhe,
Page 133, minutes.
133.
Lords, just about 7-8 lines from the before para 7. Moreover, when the government is exercising the powers conferred under subsection 1 of section 3 read with section 8 of the so and so, rule has to be laid before both the houses of the state legislature. If both the houses agree in making the modification of the rule, or both houses agree that the rule should not be made, rule shall thereafter have effect only in such modified form or be no effect. Hence, this tribunal may consider the above aspect and meet service.
Meet the ends of
Yes.
justice. Yes, they have taken up the contention. Where is your reply?
Reply, yes, my lords. Reply they have filed.
Have they
which is
stated
page
that they were
2
laid before the house?
Page 262, my lords. They have not.
That's very important. Jain and Jain on administrative law. Of course, when I was a student, it was 4th edition. Now 6th edition has come by Justice Arade.
Yes.
He also has dedicated one chapter on that. The administrative control, legislative control of administrative action, which includes quasi-legislative action. A separate chapter is dedicated on that. This one, even in vide in administrative law, these things are treated. Apex court said, where laying is a legislative control of quasi-legislative action, because the rule-making power is quasi-legislative. So they have taken up a contention. Where have you met it in your reply? One single sentence. Yes, we had laid it before the house. Show that. Get that Atlas cycle. Take that Atlas cycle.
But we'll get instructions in this matter.
Number one.
Can be.
Number two, where is the consideration? In the habendum clause of the rules, you should have stated, so many employees have given the representation. Gist of their objection is this. We have examined this. We do not agree with this objection because of ABCD reasons. You can't make law as if East India Company would make law for its employees.
The preamble
We have a welfare
states that the
It
objections
states
are
that objections are considered. That is self-serving statement. That is a print. Perhaps you have borrowed it from some other rule and asked your press to print it. They have printed it. Where is the material to show? These are the objections. And we have treated the objections this way. Objections are unsustainable. Where is that consideration? Because it will have a lot of repercussion.
a short accommodation may be given, my lord. We'll
But
submit
till
the
then,
information.
what is happening now?
Lords, now, they have, last week they have
Don't
notified.
precipitate the matter.
Yes.
Don't
Last week they
precipitate.
have, Lords, now, there is already a dispute which was before your lordships.
The judgment apex court, you are not telling.
Lords, that is 1979.
Yes, which is the paragraph? Read.
Volume 2 SCC page
Read the
196.
paragraph.
Lords, I just read the relevant paragraph. Lords, now the policy and object underlying the provisions relating to laying the delegated legislations made by the subordinate law making authorities or orders passed by the subordinate executive instrumentalities before both the houses of the parliament being to keep the supervision and control of the aforesaid authorities and
Correct.
instrumentalities. The laying clauses assume different forms depending on the degree of control which the the legislature may seek to exercise. As evident from the observations made at pages so and so of 7th editions of Cries on Statute, which
Correct.
noticed with approval of Hukam Chand versus Union of India and others, and there are three kinds of laying which are generally used by the legislature. Three kinds of laying are described and dealt with in the Cries statute as laying without further procedure, laying subject to negation of resolution, laying subject to affirmation resolution. Then simple laying, negative notes, then it goes on to
That's
the
what-
details.
That's the law,
That's,
which is the latest judgment which reiterates that view.
but there is one,
Latest
22,
judgment I have
there is
seen
one,
by Justice Nariman.
yes, my lord, this judgment is relied upon 2022 Supreme Court, my lord. So I'm able to open it here.
Very good. Yes, brother, what is that? They have made the case. Where have you stated in your reply that we have laid it? Show one sentence. Rules were laid in the house. 5 words. Rules were laid. Sufficient.
ಮಾಹಿತಿ ತಗೋತೀವಿ ಸರ್ ನಾಳೆ
My thing, you can't say that
Kindly.
way. But don't precipitate the matter. They have made out a case. They have made out a case. They have taken up that ground. Issue emergent notice. Then entry matter in ಕೇಳಿರಿ ನೀವು.
Lords, we have sought for stay of that notification to convert state cadre, district cadre to state cadre.
stay of the rules itself.
Rules, we are not.
Lords, your lordships,
They are all ಬರ್ಕೊಳ್ಳಿ. The learned AGA he is requested to accept notice for official respondents. Matter in terms of rule under challenge, schedule to the rule under challenge shall not be precipitated till next date of hearing.
Please.
First, this interim protection has been accorded in view of the following two major reasons. One, the contention as to laying procedure has not been denied in the reply statement of the state before the tribunal. Number two, the amendment to the rules, although states that objections were considered, does not mention anything as to what the objections were and why such objections are not maintainable. Okay.
Please, Milords.
Reliance is placed. First, the reliance is placed. Atlas cycle versus
Atlas Cycle versus State of Haryana,
State of
1979,
Haryana.
volume 2, SCC, page 196.
Office objection comply madi.
Please, Milords, I shall. Great.
Okay. Objection ready ಮಾಡುವಾಗ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಬುಕ್ಸ್ ಅನ್ನು ಇಟ್ಕೊಂಡು ಅಬ್ಜೆಕ್ಷನ್ ತಯಾರಿ ಮಾಡಬೇಕು. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಹಿಂಗಾಗ್ತದೆ. You should read at least about 2-3 books. Vide on administrative law, Jain and Jain administrative law, P. Messi on administrative law, and there is one more Professor S.P. Sathe on administrative law. These standard books should be read. Then lawyering blossoms. Not only students, more particularly constitutional law lawyers, they should know complete administrative law because administrative law is a soul of constitutional law. Yes.
Serial number 18, government advocate.
Yes.
ಬೆಳಗ್ಗೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದೆ ರೆಗ್ಯುಲರೇಷನ್ ಆಫ್ ಸ್ವೀಪರ್ಸ್ ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ಸ್ ವಿಚ್ ವಾಸ್ ಅಲೌಡ್ ಬೈ KIT that was challenged before Dharwad bench. Your lordship dismissed the writ of the filed by the government or given the order identical matter.
Lord, identical matters are pending before this honorable court on 9th April, my lord. The matter was argued by Shri Ahmad, my lord, S.A. Ahmad, AG. That matter is still pending. The issue is whether they were appointed to a pensionable post or a non-pensionable post.
That's the only point.
That is the only point. And I have a decision of the honorable apex court.
Matters have post ಮಾಡಿದ್ದೀವಿ. Other connected matters are posted when?
But I will give the number, my lord.
ಎಲ್ಲ ನಂಬರ್ ಕೊಡಿ
I'll find out.
next week ಹಾಕೊಂಡ್ಬಿಡ್ತೀವಿ ನಾವು.
That
Agbodu, sir.
where reply model, that contention was raised earlier, that has been rejected, my lord, and it has went up to Supreme Court, my lord.
But I have a decision of the apex court on which I am relying, where the distinction is made between pensionable post and a non-pensionable.
Call this matter along with the
44784 of 2018, my lord.
ಮತ್ತೆ ಬೇರೆ ಎಷ್ಟಿದೆ ಎಲ್ಲದನ್ನು ಕೊಡ್ಬೇಕು. ಒಂದ್ ಕೇಸ್ನಲ್ಲಿ ಅಷ್ಟು ಮುಗಿದು ಹೋಗ್ಬಿಡ್ಬೇಕು. ಒಂದ್ ಕೇಸ್ ಇದಕ್ಕೊಂದು ಅರ್ಧ ದಿವಸ, ಆ ಕೇಸ್ಗೆ ಅರ್ಧ ದಿವಸ, ಹಂಗೆಲ್ಲ ಎಲ್ಲಾ ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಡಿ ಮುಗಿಸ್ಬಿಡ್ತೇವೆ. ಅದು ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಆಲ್ಸೋ
I'll give it by the end of the day, my lord. Before your lordship.
call this matter along with the WP number so and so and also other similar matters, list of which would be furnished by the government advocate before end of the list. Yes.
Serial number 24, government advocate.
The appellant state.
Yes. Yes. What is this matter about?
Matter pertains to an investigation that is carried out by various wings of the GST machinery, led by the enforcement wing. We come to a conclusion that there are two ringleaders or kingpins involved in bill trading, recirculation of invoices, creating fake dealers, creating fake entities, and procuring goods from somewhere else. They are summoned for questioning. They provide zero cooperation, false, inconsistent, evasive answers, destruction of evidence, and threatening intimidation of witnesses. and the offense continues. In light of all this, we conduct a search and seizure operation. One of them, who claims to have not be able to answer my summons because of medical reasons, but he's traveling all over the country, jumps the wall and escapes. Another one sends a message to his relatives, I'm running to Hyderabad, but is intercepted in Bangalore city, taken for questioning, and therefore thereafter the arrest is recorded. He is taken before the special court. Mahajar is drawn up, pancha witnesses are there, arrest memo is there, grounds for arrest are there, everything is served, videography of his arrest is made. He is taken for medical examination, seizure memo is made. He is produced before the special court. Special court, he files application for interim bail, heard, rejected. The day on which his interim bail is heard and rejected, a writ petition under the classification of tax residual is moved, questioning my investigation, legality of my investigation. That is on the 28th of March. 29th, 30th, 31st are holidays. On the 1st of April, he is released on bail, saying that the order will be communicated telephonically to the jail authorities. I receive the certified copy of the order. No reasons are uploaded. Operative portion is uploaded. I receive a certified copy of the operative portion on 15/4. 15 days after.
Order is received on which date?
My lords, order is made on 1/4. Only operative portion of the order is uploaded.
1/4.
1/4 order is made. Only operative portion is uploaded.
Generally, bail matters, because I sat on the criminal side for a short period. Only operative portion, only we direct the upload.
Communicated telephonically.
1/4 order is made.
Yes.
Reasons are furnished when?
Reasons are furnished in the afternoon of 16/4. After, and my certified copy, my certified copy of the application is used on, that certified copy is released on 15/4. I am provided only the operative portion again in the certified copy.
On 16/4 reasons are given.
Yes, 15/4. I stand corrected. 15/4 afternoon, 1:44 p.m.
Where is that?
Let us see. I'll show. Your lordships may see the page 27. I have also your lordships may come to page 35. Since then I have got the certified copy, etc. Kindly come to page 35. Your lordships, last updated on 25/4/15, 2025 April 15, 144:57. In the meantime, where are the certified copy compilation? This will make it clear. Before I dive into the merits. This one. Give the other side. Court of. I'm just producing a memo. Just I want to. Your lordships may kindly take page 1 of this memo. At 6:02 p.m., the operative portion, in view of aforesaid facts and circumstances, it is uploaded. No difficulty. My lords.
What you want to say us?
But I am just this at 18:02 on 1/4, the operative portion is uploaded. The next day I make a certified copy application. Kindly see the certified copy that I'm given on 15/4.
Where is that?
At page 4. After 15 days, my lord, I'm again given the operative portion. And whereas, kindly see the initials of the assistant registrar, writ unit is all on 3/4, everything was ready. It takes 15 days to give only a certified copy of the operative portion. After my certified copy application is exhausted for this copy, the reasons are uploaded, which is the next page. Your lordships will get that
Yes.
on page 14. At about 11:30, I received this certified copy. Then the reasons are uploaded, forcing me to make another certified copy application. Which, anyway, I get. The point, my lord, is that there is haste in granting bail, but somehow, somewhere in the system, I am unable to take recourse against that order. Be that as it may, my lords. Now I'll come to the merits.
Do you have power to arrest?
I have power to arrest.
Show that section.
Kindly see, my lord. Section 69 of the Act, GST Act. So I will
GST Act ಕೊಡಿ. ರಾಧಿಕಾ ದ once case ಕೊಡಿ.
Is it on par with power to arrest under CRPC?
I need authorization from my commissioner. That's all. And everything is in place. Well, I've earlier in my career, I've had the occasion to do some criminal work. In some matters, I worked with counsel like Mr. Siddharth Luthra, KG Menon, etc., when they were appointed special public prosecutor. Except those matters, my lord, where a doyen like Mr. KG Menon or a lion at the bar like Mr. Siddharth Luthra has been appointed special public prosecutor, I am yet to see a case with fuller documentation. Your lordship may kindly take 69 of the Act. Power to arrest.
Power to arrest. Please face.
Power to arrest. Where the commissioner has reasons to believe that a person has committed any offence in clause A or clause B or clause C or clause D of subsection 1 of section 132, which is punishable under clause Roman 1, 2 of subsection 1 or subsection 2 of the subsection, he may by order authorize any officer of central tax to arrest such person. In the KGST Act, it becomes my officer of the state enforcement. Then, when a person is arrested under subsection 1 for an offence specified under so-and-so, officer authorized to arrest shall inform such person of the grounds of arrest and produce him before a magistrate within 24 hours, subject to provisions of Criminal Procedure Code. When a person is arrested, so-and-so, he shall be admitted to bail. In the case of non-cognizable and bailable offence, Deputy Commissioner shall.
Where a person is arrested under subsection 1 for an offence specified under subsection 4 of section 132,
Yes.
he shall be admitted to bail.
Oh, yes.
So bail will be.
Not applicable. Not applicable because this is so far as 132(4) is concerned.
This is the one which you have invoked is
132(1).
132(1). This is 132(4). 132(1) is what?
Malice. Punishment for certain offences. Whoever commits or causes to commit and retain the benefits arising out of any of the following offences: supply any goods or services or both without any issue of invoice in violation of the provisions or the rules made thereunder with the intention to evade tax, issues any invoice or bill without supply of goods or services or both in violation of the provisions of the Act or the rules made both or rules made thereunder leading to wrongful availment or utilization of input tax credit or refund of tax, avails input tax credit using the invoice or bill referred to in clause B or fraudulently avails input tax credit without any invoice or bill, collects any amount of tax but fails to pay the same to the government beyond a period of 3 months from the date on which such payment becomes due, evades tax or fraudulently obtains refund, and where such offence is not covered under.
Which is attracted in this case?
My lord, A, B, and C are attracted, my lord.
A, B, and C.
A and C are attracted, my lord.
A and C.
Yes.
A and C supplies any goods, services or both without issue of any invoice. Did he supply the goods?
Yes, yes,
Avails input tax credit.
yes.
Has he availed input tax
Yes,
credit?
yes, yes, yes.
Where are the foundational facts you have alleged against him?
Manoj. It is there in the remand memo, which is on record, but let me just, the detailed investigation note, which is not different from the remand application, but I just, in order to give it.
Are there any other cases filed against your client?
No.
Any
No, my
other
lords.
criminal? Just verify and tell it.
No, my lords. ಅದು ಇದೆ ಅಂತ ಇಲ್ಲ
Ask them, just,
ಕೇಳ್ದೆ.
he's just nodding the head. That
ಇಲ್ಲ
will
ಇಲ್ಲ
not
ಅದಕ್ಕೆ
help.
ಕೇಳಿದೆ.
That will not
Are there
help.
any other
Ask him
cases?
whether you go and ask your
No,
client.
there are no other criminal cases.
To file a memo.
We will file a memo to the test. You file a memo, I'll file it.
Ah. Yes, Mr. Aditya.
My lords. This is the investigation report, my lord, that starts. Your lordships may kindly take on page 2. Your lordships have it? This memo.
Yes, brother.
My lords. Findings, page 2, my lord. Page 1, your lordships have note on investigation of fraudulent.
So power to arrest is there
Yes,
and right to bail is there.
right.
If it does not fit into that subsection 4, then it fits into which section?
My lords, 5, subsection 5 of 132, my lords. Kindly see subsection 5 of 132.
Subsection 5,
Subsection 5 of 132.
130,
132,
132,
yes.
where
The offenses specified in clause A, B or C or clause D of subsection 1 and punishable under clause small Roman 1 of that subsection shall be cognizable and non-bailable.
which requires previous sanction of the commissioner for arrest and detention.
This requires, my lord.
Yeah, which is that section? Just we want to.
69, my lord, 69.
Subsection 6 also,
6 is with relates to prosecution.
lord says, to commence the prosecution
Not
and
for arrest and
section 69 authorizes the arrest.
69, my lords.
69.
Yes.
So commissioner will authorize
Yes,
arrest. Same as under
Yes.
CRPC.
yes, yes.
Ah,
Your lordship may kindly take the memo that I filed with the note on investigation.
yes.
Yeah, I'm on page 2, my lord. Findings in brief. Findings in brief. In the case at hand, as the entire investigation revolves around the fraudulent evasion of tax, the interplay of this investigation is whether actual supply of goods, services, both has taken place in the hands of the registered person who have the purported tax invoices. In this background and based on intelligence inputs, the investigation has been conducted to ascertain the factual matrix from multidimensional angles. Accordingly, incontrovertible evidence have been gathered from various sources, paper trail and money trail. The physical delivery and possession of goods is the essential condition to qualify a transaction effectively under 7(1) of the CGST SGST Act. This being the legal position, in the present case, such event has never happened. Therefore, issue of invoice without supply of goods has no effectiveness in the eye of law. Obviously, no physical transfer of goods can be said to have taken place in the document called invoices issued by bogus entities. Fake invoices, e-way bills issued by bogus entities to Mr. Lavarga Metal Private Limited, Polar so and so. The final and end user do not establish the fact that there was an actual supply of scrap, much less collection remittance of GST, CGST shown. This is much against the fundamental so and so. Then kindly come to the next paragraph. Your lordships had asked about the supply of material. The investigation has clearly established that there is no actual supply of various kinds of metal scrap from the persons who have issued tax invoices to Lavarga Metals Private Limited, the final end user. Rather, this recipient has obtained scrap from unregistered persons through the well-organized pipelines. To legalize such kind of actual procurement of scrap from unregistered persons, it has caused to issue fake invoices to derive and retain the benefit of income tax credit to reduce the output tax payable. Further, during the investigation, it is evidently proved that this is a clear case of forgery of documents, creation of false and fabricated documents, which are pretended to be genuine, so and so, so and so. Then your lordships may kindly come to
What for you need his custody?
he gives evasive answers, false answers. His answers are contradictory in every interrogation. He asks his driver to delete messages. He asks people to move documents. Therefore, my lords, I intend to break this ring. I need to confront him with various witnesses.
Do that and send him home.
No, my lords,
Why he should be detained?
lords, without detention, my lords, he's only in my office to have coffee. There is absolutely no pressure on him to speak the truth.
That means that amounts to pressurizing, which offends Kathi Rani Rawat versus state of Saurashtra.
No, because without custody, my lords, he will be needless to say, every rule that is prescribed for persons in custody is respected. Without such custody, he is evading.
No, we will tell him to sit in your office from morning when sun rises until sun sets.
Yes. Very well, my lords.
Yes.
But it has to be on a daily basis, my lord, because it cannot be on his whims and fancies.
Every day.
Every day.
How long? 365 days?
May I just,
Until completion of my investigation.
may I just,
One second. Please.
my apologies.
Don't disturb. Yes. See, you want
Yes.
him for interrogation.
Yes.
Anyway, you cannot manhandle him as the law.
Not at all, my lord. Far be from it.
Number one.
Yes.
Investigations of the kind you can do from morning sunrise to evening sunset.
Yes.
Little beyond also.
Yes.
In the meanwhile, you provide him food also,
Of course.
or at least permit him to take lunch box and
Yes,
or
yes.
permit him to eat.
Yes.
He will answer every question. When do you want?
For a period of 90 days, 5 days a week, my lord.
How long you want?
90 days.
90 days.
90 days.
Show me one single case in the country's history where for the purpose of interrogation, 90 days custody is given. One single case.
My lords, it's
One single case
One
from
of-
any textbook.
when I have,
You are also wide range reader.
Yes.
I understand. Show me one single case where a person's custody can be sought for 90 days because you want to know the tax evasion mechanism. Show one single case.
the statutory bail, my lord, it kicks in depending on the offense, 60 days or 90 days. I am only asking if he had been in my custody and I had not filed charge sheet, either in judicial custody or in department custody, and I had not filed charge sheet, he would have been entitled to be enlarged after 90 days. That's all I'm asking.
No, that's no answer. That's the bail jurisdiction, bail or jail. You know that what Justice Krishna here said. Bail is a rule and jail is an exception.
Yeah. Unfortunately, my lord,
No, we will keep him in your custody only. Custody in the sense,
morning to night.
morning to evening.
I leave 60 days, my lord. I leave it to your lordship.
Why 60 days? 60 days. Brother, you just,
I leave it to your lordship. my lord.
no, not like that. It should be some
I'll take it.
normative basis. Some normative way. Ask your officers, from what time to what time? For how long? It's a liberty of citizen is quite important.
Section 187 of the BNSS permits 15 days police custody. That's what I wanted to submit. I'm sorry, my lords. Under the scheme of the GST Act, custodial interrogation is not permitted.
What for arrest and detention?
Lords, that's the reason why I said, if he's arrested, the next provision it is there, my lords.
It should be produced within 24 hours.
24 hours,
before the
that's it.
magistrate.
Provisions akin to section 187 of the BNSS is conspicuously absent in the GST Act.
I'll answer all that. If
The Radhika Agarwal's case, but I am not going on that. 15
Radhika
days.
Agarwal is completely in my favor.
Ask him, make him available for interrogation.
Please.
Why-
Lords,
suppose if we write
this is,
judgment,
kindly have a look at this, because if they are making a statement, Millards, whenever they have called, for how much ever long they wanted me to be there,
You will
I am there. Kindly have a look at this memo. After this order is passed,
one second.
I will go. 15 days, Millards, is what is permitted.
There is something, that can be faltered in the process that this order has come out.
Yes.
That is one part. That's a fault with us only. Therefore, there is no fun in
Getting into that question. yes,
celebrating our own fault. Appears to be not a good way of dealing with the matters of this kind. That being said, instead of we writing some jurisprudential answer, judgment, and curtailing citizens' right, because many aspects go through.
Yes.
When we don't want to, as of now, if it comes to that, we'll write the judgment. Maybe it may be set aside. If we write against you, we will go to Supreme Court. Anyway, it will not stop here. If we write against him, at least few days he will be in your custody till unless he evades police, etc. Instead of that, now we are saying, let them investigate.
Lords, I made a statement even before the learned single judge saying that Lords may put me on terms. I am ready to fully cooperate. One of the conditions, Millards, is that I will have to fully cooperate. If they now make a statement, Millards, I stand guard against what I am saying. If they now make a statement that I have violated the orders of the learned single judge, which imposes a specific condition that I am required to cooperate with the investigation, I am in your Lordship's hands. Millards, there is not even a single instance where I have not cooperated with the
No, he
investigation.
did not say that. He says the way the order has come out
Millards,
gives
now,
a scope for,
yes, Millards.
see, some judge of this court has made an order. We have great respect for the judge. That's
Yes.
another thing. The way the matter is treated, there is some objection. There are elements of, the falterable elements in this, the process. I'm not saying that on right of bail, etc.
I could say this. Millards.
Order appears to be, it gives a bit different impression.
Millards,
Anyway.
Millards,
we'll
I
not
wanted
say
to say
beyond
this, Millards, I just wanted to say this. That is not in my realm, because in some circumstances, Millards, we take the operative portions of the orders, especially the
No, no,
bail
not
orders.
about you.
Yes,
We are on our system only.
yes.
As
But
you
now,
rightly said.
Millards, if your Lordships were to see the order impugned, it refers to several judgments of the Supreme Court. It extracts the relevant portions and probably for
I'm-
corrections, etc.,
I am going to
etc.
meet all of them.
It
My
is-
friend wants to go down that.
If
path.
it is probably for that reason, I'm not getting into that question.
Now,
Millards.
now Aditya.
Question is about it, because their apprehension is whether I am going to cooperate with the
But I
investigation
tell
or
you one
not.
thing.
I am cooperating.
I tell you, cases of this nature are worse than murder
Yes, correct,
because
Economic
they murder
offences.
the economy
correct.
of the domestic economy.
Lord, Chidambaram's case has
There
taken
we
a
have to be
specific view.
doubly careful.
True, Lords.
There the preference is of the state, not citizens' liberty.
Lords,
That view is available. At least two judgments you have written that way. Two of them have been affirmed by the apex.
Lords, Chidambaram's case itself very specifically said economic offences are a different
Most
category.
dangerous they are.
No difficulty, my lords. Now the question is, section 187 is conspicuously absent under under the GST Act. So custodial interrogation is something which is, I don't know from where they are asking that after arrest we are going to get the custody, because provisions of the CRPC post arrest and post judicial custody is not there under the GST Act. Lords, they are reading into the GST Act something which is not there, but I'm not getting into it. Lords, what is that they require? I should fully cooperate with the investigation with my constitutional
Understand
safeguards against
But the
self-incrimination.
point,
I will
now-
do it.
Now you say that your client is ready and willing
Yes.
to go for interrogation from morning to evening.
From 10:30 to 5:30 minutes for 15 days, your lordships may
But
permit.
10:30 to
whatever.
5:30
I
is like
just
school.
get the ಕೇಳಿ, ನೀವ್ ಹೇಳಿ.
9 AM to 9 PM, my lords, 30 days.
9 PM.
What is this?
After evening.
ಇಲ್ಲ, ಏನ್
6 PM,
ಮಾಡ್ತೀರಾ
6
ನೀವು?
PM. 9 AM to 6 PM for 30 days, my lord.
All right. ಅಲ್ಲ 30 days ಆಗೋದಿಲ್ಲ. ಪೊಲೀಸ್ ಕಸ್ಟಡಿನೇ 15 ದಿನ
ಒಂದ್
ಕೊಡೋದು.
ನಿಮಿಷ 15 days ಮಾಡಿ
ಅಷ್ಟೇ.
ಮುಂದೆ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ. We will keep this matter pending.
Seek extension.
Seek extension.
Your lordships will grant me liberty to seek.
That's why.
Very,
Please.
very well.
Both the sides having argued the matter vociferously against each other, now graciously agree with the suggestion of this court that
the respondent dealer ಏನಂತೀರಿ ಅವನಿಗೆ?
No, he's individual, my lord.
He's an assessee.
Respond, not
He
as-
is, he is a director of a company.
He's the directing will and mind of the company, my
No,
lord.
what I should call him?
Accused, my lord.
Accused ಆಗ್ತಾರ? He
Accused
becomes
ಅಂತ ಹೇಳಕ್
accused.
ಬರೋದಿಲ್ಲ GST ನಲ್ಲಿ.
ಅಲ್ಲ, he becomes accused
My lord.
at a particular stage. Not by your arresting, he becomes an accused. No, law is not that. That
Respondent.
in Lalit Kumari, they have said when a person becomes
Becomes
an
an
accused. First respondent,
R1.
Mukund Agarwal.
Please.
The first respondent, Mukund Agarwal, shall avail himself to the, to the petitioner authorities, appellant
Appellate.
authorities for interrogation during the period between 8 AM to 6 PM.
My lords.
6 PM. First stop. 6 PM for the initial period of 15 days with liberty to the appellants to seek extension thereof by showing cogent grounds therefore.
Lords, if law permits me, lords, because I will be still,
Procedure court will be always law only.
no, because if your lords were to
By
say so,
showing
it should not,
cogent grounds, they're not only law,
please.
grounds they have to show.
Because my contention, my lords, is that custody beyond 15 days is not permissible under
Let us
any
see.
scheme of the statutes, my lords, prevailing in this country.
In connection with the issue of extension, contentions of the parties will be considered when extension is sought for.
Lords, so grateful, my lords.
With permission to move vacation bench.
First off, it hardly needs to be stated that it hardly needs to be stated that it is open to both the sides to move the vacation bench if need arises.
Please, my lords.
If need arises.
Well, it's the conditions of his release, there's no tampering with witnesses or evidence and
All usual conditions as would obtain in the erstwhile CRPC would apply
Lords, the
to
learned,
this arrangement.
lords, the learned single judge himself has imposed all the conditions.
Therefore, we said that,
Please, my lords.
all conditions,
Please.
including those enumerated in the learned single judge's order.
Please.
All right, anything more to be done?
I'm obliged.
But tell your officers, they are not undertaking skilling of Himalaya.
Not at all. my lords. Not at all.
Therefore, you should ask your officers to be more vigilant and put intelligent officers, not all substandard officers. They will put 100 questions. What is full stop? What is comma? What is inverted commas? Useless things we have seen.
My lords,
Put most efficient officers there so that time will be saved. Your time will be saved.
I understand.
Efficacy level. Only thing is officers of very sharp intellect and commitment.
I bowed out,
Put
my
them.
lord.
They are very few in number. We know. I have been sitting on the taxation. But we have been sitting on the taxation
Lord,
seat
if the-
as substandard as can be.
If the opportunity presents itself, my lords, I will take your lordships through how the modus operandi has been unearthed.
We
matters not on merits. I don't know why the,
No.
no.
Investigation is not our
Yes.
cake. It's not our cake. Always it is your thing. It's a serious matter. We understand. It's not the way the learned single judge has treated this subject gives lot of scope for argument from your side.
My lords.
We agree with that.
My lords.
But since arrangement is being
I bowed
consensual.
out. I bowed out.
Call this matter.
Second week of June. Your lords may say call after vacation. my
No,
lords.
may not be necessary at all.
Lords, it may be disposed of, my lords. There is nothing
No,
further
if he
remaining.
wants extension.
If I want.
Then
to
he
make-
can make it, my
Not
lords.
only
Even a
that.
disposed of matter,
But
it
he
is
will not
permissible
decide how I
to
will move
for
it.
extension.
Court also
Decide
wants
how I
to,
move.
not only that, court also wants to watch
how they conduct with your client, how your client conducts with the officer.
Lords, I just wanted to say this, Lords. One of the, Lords, the nature of questioning, which on instructions I'm submitting, they're asking all personal information in the sense, do you have a girlfriend? Where have you gone? Lords, if this is the kind of questions, I'm not entitled to answer number one.
Yes, you are not entitled.
Yes,
to-
number
You are
two.
entitled not to answer.
Lords, then two, Lords, constitutional safeguard, once it is called as an offense, there is a constitutional safeguard not to make a statement of self-incrimination.
No, that becomes, no, you are taking us to the
I'm just saying.
larger area
Yes.
on which you may not be prepared. We are prepared. Therefore, unnecessarily don't.
Very well,
That
Lords.
level.
No, your Lordship is
it's a-
prepared in all matters. That's
No,
where
not
the.
like that, because you are treated that way. You are a very tall advocate, it's
Yes.
another thing. But we have accumulated the experience in.
I understand, my lords. Lords, so
Lord,
far as self-incrimination,
For self-incrimination question arises only when he becomes accused, not otherwise.
Lords, the reason
So.
cooperation with the investigation is concerned, my
Kindly
lord.
see 7 judgment decision in Kati Running Rawat versus State of Maharashtra.
Please, my lords.
And yadu innondu PL Dani.
Nandini Satpathy.
Nandini Satpathy versus PL Dani.
Please.
Your questions are answered, your client is protected. He is protected also.
I understand, my lords. That is the reason why I said,
That's
please. So grateful, my lords. for Lordship's indulgence.
Deeply obliged.
Al Melgade, heard learned senior state counsel and learned senior advocate appearing for the respondent. Yes. All.
I'm deeply obliged.
Okay.
Serial number
Very good.
37, Basavaraj Patel.
Mr. Aditya and Ravi, please call Ravi. Ravi, in the event your client does not cooperate, in the sense he does not go, then we will permit them to arrest him.
My lords,
Yes, if he does it, no problem.
I wanted to say this, my lords. I'm making a statement before the court that we are going to go whenever this 15 days your lordships have fixed. Lordships may say from tomorrow till so and so date. I'll not miss.
From which date?
From which date, let them say.
Ask them, from
Somehow-
which date he want. The only, Aditya, only thing is you have to put most of the efficient officer there, not some substandard officers.
No, man. not-
Yes,
But 15 working days from tomorrow, my lords.
from tomorrow.
Yes.
But he also has to make arrangement for his business, etc. Give one day, so that he will make,
Very well.
ಎಷ್ಟು ಸರಿ ಡಾಕ್ಟರ್ ಹತ್ತಿರ ಹೋಗ್ಬರೋದು ಇರ್ತದೆ,
Very well.
ಮೆಡಿಸಿನ್ ತೊಗೊಳೋದು ಇರ್ತದೆ. He will make arrangement.
Monday, my lords, 15 working days, my lords.
15 working days. Huh? With effect from Monday?
28th,
28. So that he can also arrange, na? He
Very
is a
well.
citizen after all.
please.
Other things, food, ಇದು ಎಲ್ಲ ಮೆಡಿಸಿನ್
Needless to
ಎಲ್ಲ
say.
ಬಿಡಬೇಕು
Needless to say.
ಅಲ್ಲಿ ಬರ್ಕೊಳಮ್ಮ.
I mean, even if
They-
requires medical assistance,
He's a youngster, my lord.
ಪ್ರಶ್ನೆ ಕೇಳಿ ಏನಾಗ್ಬಾರ್ದು ಅಂತ ಅವ್ರಿಗೆ.
ಹಾ, ಏನ್ ಗೊತ್ತಾ?
Everything.
No, ಪಾಪ, he may be innocent also, we don't know.
No, he's been
Presumption
produced
is
before.
innocence. Presumption is that he is innocent.
Yes, absolutely.
ಪ್ರಶ್ನೆ ಕೇಳಿ ಡಿಪ್ರೆಸ್ ಆಗ್ಬಾರ್ದು.
He shall not be subjected to any ill treatment or harassment.
Please.
We don't know. That's we don't.
I'm obliged.
All.
Serial number 37, Basavaraj Patel, GK.
Petitioner seeking regularization, covered by judgment.
Covered by judgment. Covered, Henry?
36 years was working, my
My
lord.
lord, in this.
36 years.
Yes.
36 years, my lord.
Then my brother's judgment is covered, it covers.
My lord, they have submitted several judgments of this honorable, this honorable court as well as the apex court, where it has been held that if the appointments are illegal and not
You
illegal.
have argued that so many times.
Yes, my lord. But that is the ground on which the endorsement is also issued.
What is that illegality?
My lord, the initial entry is not through open competition.
That is not itself is not illegal.
But my
That
lord,
per se is not illegal. That has been watered down. That was there earlier. That has been watered down.
very recently in Upendra case, my lord, in 2018.
Recent judgment, Junjappa case, my lord, has covered.
Allah, if they are relying on Jagos case, my lord,
No, our judgment, which we have considered all aspects which you argued other days. My brother has wrote that judgment, na?
They have to
Live law.
demonstrate that it is irregular and not illegal, my lord. May I
Irregular.
just,
Correct. What is irregular, what is illegal is the question.
please, my lord, may I just draw your lordship's attention to this
No,
judgment of
36 years you have allowed him to be illegal. Answer the question. Can state allow somebody to be illegal for 36 years?
My lord, the judgment of the apex court in Umadevi's case also recognizes the right of the government to appoint on contract basis.
But this is not on contract basis.
This is on daily wage basis.
Daily wage basis is not a contract appointment.
My lord, whether it is daily wage or ad hoc appointment, my lord, this is the,
The matter
my
is,
lord, in fact,
the subject matter of this petition is substantially similar to the one in the petition number. So
Lord,
it's-
may I just
All
draw your
contentions
lordship,
will
just one judgment of the apex court. This is, in fact, Honorable Justice Ravindran's judgment, because ML Kesari's judgment is relied upon often, and my lord, I respectfully point out, my lord,
36 ವರ್ಷ work
in
ಮಾಡಿದ್ರೆ
ML Kesari,
ಕಳಿಸಿದ್ರೆ.
in ML Kesari, my lord, page para 12, my lord, para 12, page 435. My lord, I respectfully submit in ML Kesari, Honorable Justice Ravindran points out when it is illegal. It is pointed out if it is without educational qualification required for that post.
Is it your case
Or-
that he does not have educational qualification?
I'm just clarifying one point. Actually, there is the judge, in fact, in this, it goes further and actually points out what is illegal in Umadevi's case, my lord. If it is not appointment through open competition, that is brought out in this case. Although in Kesari's case, that is not
there.
mentioned by the same judgment, maybe. My lord, in Upendra's case also, my lord, in 2018, it is very important to that the appointment is irregular and not illegal. And what is illegal is when they have been appointed to the exclusion of many others. My lord, in para 5 of Umadevi's case, it is one important observation is made by the apex court, my lord. We are considering the right of the contractual appointees who are before the court. What about the lakhs of people who covet this particular post and never had the opportunity to compete for this?
Correct. But that question cannot arise after 36 years.
But, kindly see this, my lord.
Well,
Para 12.
ಅಲ್ಲ, ಎಷ್ಟು ದಿವಸ ವರ್ಕ್ ಮಾಡಿದ್ರ ಆ ಕೇಸ್ನಲ್ಲಿ, ಎಷ್ಟು ವರ್ಷ they were in service?
My lord, it says in Upendra's case, it is said that any length of service cannot confer legitimacy on an illegal appointment.
Correct.
Please.
Even illegality, the degree of illegality diminishes.
Please.
In other words, the illegality is inversely proportional to the length of the services put in.
My lord,
To put it in mathematical way.
but that is only in so far as sanctioned post is concerned. The whether if they have been appointed against
They were all part-time workers in that case.
Upendra's case, my lord, in Upendra Singh's case, which is 2008 volume 3 SCC 680, my lord, an illegal appointment is void ab initio made contrary to the mandate of Article 14, because equality of opportunity for everyone is not there, my lord. Open competitive selection cannot be regularized under any circumstance. Irregular appointments can be regularized if the appointment was made by an authority competent to do so. It was made on a vacant sanctioned post in accordance with Article 14 of the Constitution, with equal opportunity for participation in other eligible by competitive selection, and candidate possess the eligibility qualification for a regular appointment to the post. Therefore, when they have been appointed to the exclusion of others, my lord,
In all cases,
it can never be regularized is what
in all cases it happens. In every case, it has happened.
indeed.
Not only that, see, we want to formulate we want to articulate one proposition now. The illegality, the arguable illegality is inversely proportional to the length of service you have extracted from a
But
citizen.
that issue is no longer res integra is my respectful submission because of para 12, my lord, of this judgment. I'll just
We'll
read.
consider.
My lord, just
that
this,
also.
may I
Para
just
12
read
also.
one paragraph.
But
This is the only. We may at the outset refer to the following well-settled principles relating to regularization and parity in pay relevant in the context of these appeals. The High Courts, in exercising powers under Article 226 of the Constitution, will not issue directions for regularization, absorption, or permanent continuous unless the employees claiming regularization had been appointed in pursuance of a regular recruitment in accordance with relevant rules, in an open competitive process against sanctioned vacant posts.
No, where is the
Equal-
requirement of regularization if he is so appointed? What the apex court is saying? You can't read one sentence that way. If he is appointed according to rule, where is
I'm-
the question of regularization?
My lord, I'm happy that your lordship, I'm glad that your lordship has put this question to me. My lord, there have been cases, my lord. In fact, one of the first cases I argued in this court and successfully, my lord, it was a case when there was a financial austerity measure taken in the year 2003 and regular appointments were banned, my lord. And one of the recruitments which was made when this austerity measure was in existence, my lord, in 2003, was appointment of assistant engineers and junior engineers in KPTCL. They followed all the rules, my lord, including open competition, merit and reservation. However, the appointment was made on contract basis. There are situations, my lord. In fact, there is a judgment by Honorable Justice U. Lalit, in which case, my lord, it is a later judgment, in which case the Honorable Supreme Court holds, even if the appointment is termed as contractual, they are substantive appointments if all the rules are followed. My lord, therefore, my lord, once Article 14 and 16 is violated in the recruitment process, the constitutional scheme for public appointment is violated, and in no circumstances that will length of service will confer legitimacy on such this one. That is my respectful submission. My lord, there are several judgments. My lord, I respectfully submit this point has been overlooked by the government and which has been taken advantage by the private respondent seeking regularization. Because the government circular which came in 2006 following the decision of the apex court in Umadevi's judgment ignores the very first condition, which is the appointment should be irregular and not illegal. The very first condition is ignored by the government when it formulates the 4 conditions.
Next week,
Yes, he was appointed vacant post. I produced the document.
No. Some
My lord,
other
I
point
will
he's
not
saying, we'll have it next
contest
week.
because Nihal Singh's case covers, it has carved out an exception to one
No,
of the
what
conditions.
you say is, even when all laws relating to recruitment are followed, still there can be element of illegality. No, we'll consider that.
When everything is followed, my lord, there can still be a contractual appointment.
Can be contractual appointment.
I will produce the judgment of this honorable court, my lord. It's a single judge's decision. It was one of the earliest decisions where, in fact, retrospective regularization was ordered in that case with all arrears, and KPTCL complied because
That may not be a correct position, we agree. But anyway, something we are saying.
I will bring
that
the
requires
judgment of the
consideration.
Honorable Justice U. Lalit also.
Call this matter on 29th, please. 29th, Raja illa tane?
Illa sir, illa.
What? Please.
Grateful. ma'am.
My lord, may I make one submission?
Both are good.
My lord,
Yes.
may I make one submission? My lord, serial number 32 only. Contempt was initiated against us, my lord.
32 na?
32 only. State writ.
ಬರ್ಕೊಳಮ್ಮ.
Government.
Issue emergent notice. Stay of ಏನದು?
Cut,
Entry order as prayed for ಅನ್ನೋಣ?
Yes, my lord.
ಏನಂತ ಕೇಳಿ ನೋಡ್ಕೋ.
Interim order. Stay of KT order, my lord.
Interim order as sought for till next date of hearing. First, this interim order is granted on the submission of learned state council that his officers are facing contempt action
Yes, my lord.
before the tribunal.
Yes, my lord.
In CTA number,
I'll furnish.
before the tribunal.
The judgment, the case which should be connected with the matter relating to.
ಅದನ್ನೊಂದು ಕೊಟ್ಬಿಡಿ.
There's one more case, my lord, I found out.
ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ ಮುಗಿಸ್ಕೊಂಡು ಒಂದು ಅಂದ್ರೆ ನಮ್ಗೆ ಟೈಮ್ ಸೇವ್ ಆಗ್ತದೆ. ಪೀಪಲ್ ವಿಲ್ ಬಿ ಹ್ಯಾಪಿ. ಸುಮ್ಮನೆ ಎಲ್ಲ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಊದ್ದ ಬನ್ನಿಯಿಂದ ಹೇಳ್ಕೊತ ಹೋಗೋ ಬದ್ಲಿ ಎಲ್ಲವನ್ನು ಪೈಲಪ್ ಮಾಡೋದು ಮುಗಿಸ್ಬಿಡು. ಆ ರೀತಿ ಇರೋದು
My lord, there
ಎಲ್ಲರಿಗೂ
may be other cases also, my lord, but I need time to verify and may I move the matter, my lord, before this.
ಅದನ್ನ ಈಗ ಇದ್ರ ಜೊತೆ ಬರ್ಲಿ ಉಳಿದಿದ್ದು ಇದೊಂದು ಮೆಮೊ
ಉಳಿದಿದ್ದು
ಹಾಕಿ
ಸಿಕ್ಕಿದಾಗೆ ನಾನು
ಕೇಳ್ರಿ, ಅದನ್ನ
immediately
move
ತಿಳಿಸ್ತೀನಿ.
ಮಾಡಿ. ಯಾವತ್ತು ಹಾಕೋಬೇಕಿದೆ
Any date convenient to your lord.
ಅವ್ರಿಗೆ ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಹೇಳಿದ್ವಲ್ರಿ ನಾವು ಅವ್ರಿಗೆ
Next week ಅಂತ ಹೇಳಿತ್ತು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಹಾಕಮ್ಮ. ಯಾವ ಡೇಟ್ ಬೇಕು ನಿಮ್ಗೆ?
Any date convenient to your lordship. my lord.
ಸರಿ ಆಲ್
Grateful. Madam. Bring that file also. Ask them to give that file also.
Madam.
18 ಅಂತಾನೆ.
Sir, at 37 gala, 37 along with.
18, madam.
Sir, number 18 da.
18 ಗೆ.
Oh, ಸರ್ 44784 ಜೊತೆಗೆ ಇದೂನು 15904
44
ಅವಾಗಲೇ 44784 ಆಫ್ 18 ಲಿಸ್ಟ್ ಆಫ್
4478
ಅದರ್ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ಸ್ ಅಂದ್ರಲ್ಲ ಅದ್ರಲ್ಲಿ ಇದು ಒಂದಾ
ಹೌದೌದು ಹೌದು
list of which will be furnished by the.
ಇದು ಒಂದೇನಾ
ಅದೊಂದೇ ಸಿಕ್ಕಿರೋದು, ಇನ್ನೆರಡು ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಬಟ್ ವೆರಿಫೈ ಮಾಡದೆ ಹೇಳಕ್ಕಾಗಲ್ಲ. ನಮ್ಮ ಗೌರ್ಮೆಂಟ್ ಆಫೀಸರ್ಸ್ ವಿ ಕಾಂಟ್.
ಎಲ್ಲ ಮೇಡಮ್ 18 ಅಂತ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್.
One, Sharda.
ಓ, ಈಗ ಅದಕ್ಕೂ ಇದೆ 29 ಡೇಟ್ ಅಲ್ವಾ? 18ಗೂ 29 ಡೇಟ್.
18, 29.
ಹ್ಮ್.
ನಾನು follow ಮಾಡ್ದೆ. List of which will be furnished by.
ಅದೇ ಸಿಮಿಲರ್
ಮೆನ್ಷನ್ ಮಾಡಲಿಲ್ಲ.
ಅದಕ್ಕೂ ಡೇಟ್ ಅಂದ್ರೆ 29.
ನಮ್ ಡೇಟ್ ಹೇಳಿರ್ಲಿಲ್ಲ.
ಅದು ಅವಾಗ ಹೇಳಿರ್ಲಿಲ್ಲ.
ಈಗ 29.
ಹ್ಮ್. ಈಗ ಫಸ್ಟ್ ಕೊಟ್ಬಿಡಿ ಸರ್, ಮೇಡಮ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಅದು ಅಲ್ಲೇ ಹಿಡಿಯಲ್ಲ.
ಈಗ ಅದು last ನಾನು ಆವಾಗ
ಕೊಟ್ಟೆ.
ಅದೇ contempt action. ನೀವು ಬರ್ಕೋತೀರಾ?
ಹಾ 7/2024 ಅಲ್ಲ? ಸರ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಲ್ಲ, ಇನ್ ಆಲ್ ದೀಸ್ ಮ್ಯಾಟರ್ಸ್ ಏನೋ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಸರ್. ಅದೇ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ರು 10 ಅಲ್ಲಿ. ನಾಟ್ ಟು ಪ್ರಿಸಿಪಿಟೇಟ್ ಅಂತಾನೋ ಏನೋ ಆರ್ಡರ್ ಮಾಡಿದ್ರು, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ 10 ಅಲ್ಲಿ. ಅದು ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ ನೋಡಿ ಸರ್, ಇವತ್ತೇ ಮಾಡ್ತಾರೆ. ಕೇಳಿದ ತಕ್ಷಣ ಯಾವ ಈಗ ಇಲ್ಲಿದೆ ರೂಲ್ಸ್ ಇಯರ್ ಅಲ್ಲಿದೆನಾ? ಅಲ್ಲಿ SCC ಅದೇ ಸೇಮ್ ಕೇಸು ಇಲ್ಲೂ ಸಿಗುತ್ತೆ. Calling to SSC, SEC 196 ಎರಡರಲ್ಲೂ ಸೇಮ್ ಕೇಸ್ 196 ಎರಡರಲ್ಲೂ ಇದೇ ಸಿಗುತ್ತೆ. ಆದರೆ ಇದು ಬರೀ ಕರ್ನಾಟಕದ ಇದು SC means Supreme Court. SEC means Supreme Court cases. After ನಾನು ಬೇರೆ ನೀವು ಬೇರೆ ಇಷ್ಟೇ. Supreme Court ಪಬ್ಲಿಷ್ ಮಾಡಿಲ್ಲ ನಾನು ನೋಡಿ ಅದೇ ಕೇಸ್ ಇದ್ದಾರೆ. ಒಂದು ಕೇಸ್ ಇದೆ ಅದೇ ಹೇಳ್ತೀನಿ. ಬಟ್ ಇದು AIR ನಾನು ಹಾಕೋದು ಅಂದ್ರೆ ಆಲ್ಟರ್ನೇಟಿವ್ ಬುಕ್ ಫೈನಲ್ ಮಾಡೋದು ಇದು ಮಾಡೋದು ಪಬ್ಲಿಷ್ ಬೇರೆ ಬೇರೆ ಪಬ್ಲಿಷ್ ಅಷ್ಟೇ. ಈಗ AIR ನ ಅಲ್ಲೇ ಕೊಡೋದು ಸಪೋಸ್ ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವಾಗ ಓಪನ್ ಮಾಡಿದ್ರೆ ಎಷ್ಟು ಆಗ್ತಿರಲ್ಲ ನೀವು ಓಪನ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಈಕ್ವಿವೆಲೆಂಟ್ ಸೈಟೇಷನ್ಸ್ ಇರ್ತದೆ. ಅವಾಗ ಅದೇ ಸೇಮ್ ಅಲ್ಲಿ ನಮ್ದ್ರಲ್ಲಿ ನಮ್ದು ಇದೇ ಇರಲ್ಲ ಏನಿಲ್ಲ ಇಲ್ಲಿ. SCC ಆನ್ಲೈನ್ ಓಕೆ. ಇದು ಲಾಗಿನ್ ಎಲ್ಲಿದು ಅಲ್ಲೇ ಲಾಗಿನ್. ಲಾಗಿನ್ ಈಗ ನೀವು ಗೆಸ್ಟ್ ಲಾಗಿನ್ ಆಗ್ಬೇಕು ನಿಮ್ದು ಇದಿರಲ್ಲ ಅಂತ ಲಾಗಿನ್ ಅದನ್ನು ಕೊಟ್ಟಿದ ತಕ್ಷಣ ಆನ್ ಆಗುತ್ತಾ ಗೆಸ್ಟ್ ಲಾಗಿನ್? ಈಗ ಅದೇ ಸಿಟೇಷನ್ ಹಾಕಿ ಸಪೋಸ್ ನಿಮ್ಮ ಹತ್ರ ಸೈಟೇಷನ್ ಇತ್ತು ಅಂದ್ರೆ ಈಗ ಈಗ ನನ್ನ ಹತ್ರ ಸೈಟೇಷನ್ ಇದೆ